Committee Room 30, signed. 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 Committee Room 30, Committee Room 30, signed. 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 Committee Room 30, Committee Room 30, signed. 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 Committee Room 30, sound. Committee Room 30, sound.
Okay, and I declare the meeting now open, and again just to ask members of the committee, or just to remind you that the meeting is being recorded. It will be broadcast throughout Parliament buildings and also online. And to remind any members, with nobody in the public gallery, but if they do, in terms of their mobile phones, and to put it on airplane mode. And then just to remind members that we have Doug, Justin and Gemma and Morris who are joining the meeting virtually. And again, just to welcome Gemma Dolan to her first meeting of the Justice Committee. I know you've been on it before, Gemma, but welcome back. Just to advise members that the proposed oral evidence session with the Department of Justice officials pertaining to the Gillen review, and also the oral evidence session on enabling access to justice programme, will be recorded by Hansard, and just to seek your agreement for this. Members content? Yep. Okay, thank you. Just to again remind members that you're obliged to declare any financial or other relevant interests that may come up through the course of the meeting, or any issues under our consideration. So again, just if you have any interest, to declare it now. I suppose just want to declare that I have an immediate family member who works in the court service. Okay, nothing else there. Thank you, news. We're going to move on to item 3, which is the draft minutes, and just to inform members that these are contained within pages 21 to 36 of the pack, and it's the minutes of the meeting on the 21st of November. Again, just to ask if you are content that this is a true reflection of the meeting, and just to indicate that. Are members content? Yes. Okay, thank you. And just to indicate that you're happy for the minutes to be signed. Okay, is there content? Yep. Okay, thanks very much. Any amendments or anything? Or people are okay? Matters arising. So just again to remind you that an item of business that was initially scheduled to be taken under the matters was dealt with at the start of the meeting. So just to have that noted. Are there any further matters arising? No, people are happy enough. Okay, we'll move on then to item 5 on the agenda, which is the Gillen review and an update on the Department of Justice's implementation. Again, just to refer members to pages 42 to 78 of your pack, and to advise that we do have officials from the Justice Department here to give an update on the review report into the law and procedures into serious sexual offences. And again, I want to welcome Julie Wilson, the Deputy Director of the Victims Support and Judiciary Division, Nigel Bloomer, the Gillen Review Implementation Team, and Claire Campbell, the Victims and Witness and Gillen Policy Branch, to the meeting. And again, I'm just going to invite you to give your presentation, and then we'll throw it open for questions.
Okay,
thank you.
And thanks for this opportunity to brief you on progress on implementing the Gillen Review. I wanted just to take a wee bit of time to highlight key developments and focus a bit on their impact. The 2020 implementation plan set out a 5-year programme for implementation, and there's been good progress against that. However, there have also been challenges, including budget constraints and uncertainties. There's been impact from COVID, and also 2 periods where we were without ministers, and these have had an impact on our ability to deliver fully within that 5-year period. And as such, the Minister has agreed that the programme's lifespan should be extended until the end of this mandate. I mentioned budget constraints and uncertainties, and most of the recommendations in the review result in new recurring costs. And so in implementing them, we need to be sure that we have funding in our budget, not only for this year, but also for that future funding will follow. And clearly that's an issue that officials across the whole system are grappling with. In terms of our work on Gillen, it's meant that we've had to take decisions around what work to prioritise within available and known resources. So that's been done collectively by the Multi-Agency Programme Board, and then agreed with the Minister. In doing that, we've been informed by a range of factors, but broadly our approach has been about how best we can meet the needs of victims, and where can we lever the most positive changes from within available resources. As the written paper that we provided to you set out, we don't think that reporting on the number of completed recommendations is the best way to gauge progress. Not all recommendations are created equally. They differ in complexity and in significance, and also in the impact that they have for victims. And for this reason, we've started to shift our focus onto what is different and who's better off. So in some cases, we're still reporting progress in terms of outputs. So what have we done? But we've developed a comprehensive performance framework that sets out measures and indicators that will, over time, allow us to report on outcomes so that we can be clearer about the impact in terms of who is better off. And some of those we're already beginning to see. We know that victims of sexual offences can be re-traumatised as they progress through the criminal justice system. They can fear that their personal lives will be put on display and that their integrity will be called into question. And the Gillen Review highlighted a whole range of issues and inhibitors that add to victim trauma and that contribute to underreporting and to high attrition rates. It also recognised the need to ensure that any new measures do not interfere with the Article 6 rights of the defendant. However, nonetheless, it made clear that the system had to improve how it protects the needs of victims and complainants. So in practical terms, what's different now? We know that the justice system can be disorientating and difficult to understand. So in response to this, complainants in sexual offence cases are now able to access new supports. There's a domestic and sexual abuse advocacy service which helps victims to navigate criminal justice processes, whilst the Sexual Offences Legal Advisor Scheme helps to empower complainants by providing free legal advice. The SOLA scheme, the Sexual Offences Legal Advisor Scheme, the SOLA scheme has helped almost 2,000 complainants to date, and their feedback has been overwhelmingly positive, that it has increased their confidence in the justice system, it's improved their understanding of how the system works, and importantly, in many cases, it's encouraged them to remain engaged with justice processes. We plan to build on this service, first of all, by establishing equivalent support for child victims, and that service is expected to launch early next year, and also by legislating to clarify complainants' rights to pre-trial third-party legal representation. So this would allow SOLAs to represent them to the court to object to the disclosure of their private material or to the introduction of their previous sexual history. As well as that, many victims have said that one of the most stressful aspects of their criminal justice experience was standing up in a courtroom to give evidence. So we've been working to reduce that trauma. New legislative provisions are now in place to protect anonymity and to exclude members of the public from the courtroom during serious sexual offence trials. And remote evidence centres, as you know, have been established in Belfast and Craigavon to reduce trauma by providing a less intimidating, secure venue away from the courthouse where they can provide evidence and where they won't encounter the defendant or their supporters on the day of the trial. We've been doing focused work to promote the RECs, and this has led to an over 600% increase in bookings so far this year. Now, it's not just as a result of promotion of it, but there's also been some IT changes that have allowed it to be a bit more automated, but a really significant increase in bookings compared to 2023. The Gillen Review anticipated that RECs would increase victim confidence in the justice system and would help to address high attrition rates. And whilst it's still really early days, it's nonetheless noteworthy that in this calendar year, up to the 1st of November, the conviction rate for completed trials where the witness had opted to use one of the RECs is 92%. Almost half of those convictions were by guilty plea, without the need for the victim actually having to give oral evidence at the trial. If I move on to disclosure then, PSNI and PPS have been leading work to improve the operation of the disclosure process. And whilst I think procedural improvements can seem detached from the victim experience, I think in reality these are making a really significant difference, particularly in helping to reduce delay. Under the Disclosure Improvement Plan, training has been delivered to prosecutors and to police officers, and new file standards have been agreed. And if I give the example of those file standards, previously in 2020, the volume of prosecution files that were being returned to PSNI as a result of failing requirements was almost 78%, and in 2024 so far it's at 11%. So those have had a really significant impact, and that helps to reduce delay, which also then has a big impact for victims. Further measures on disclosure are planned, and you'll be aware that we are currently consulting on legislative proposals to regulate the disclosure process. These would enhance protections relating to the disclosure of private information in serious sexual offence cases, including around requests for and use of third-party material such as medical records and counselling notes. And I've touched on delay. The Gillen review highlighted that delay is a really major source of stress, and it also contributes to high attrition rates. And you'll be aware that significant work is underway, and that's under a separate programme. It was Gillen recommendations, but it's being progressed under separate programme arrangements to reduce unnecessary delay in the criminal justice system. But in particular, I just wanted to touch on the abolition of oral evidence during committal proceedings, which that's already been introduced, and it's not only improving the efficiency of the process, but crucially it improves the experience of complainants, because they're now only required to give evidence at the Crown Court trial, whereas previously they would have had to give evidence at the committal proceedings. Separate work through a judge-led under-13s protocol is also reducing delay in cases involving young children. And again, this helps reduce re-traumatisation and to allow children to start their recovery journey sooner. The protocol operates in Belfast and Antrim Crown Courts, and it's delivering really positive results, including a significant reduction in the average time taken between reporting the crime and the court disposal in those cases that qualify. Criminal justice organisations participating in the judge-led protocol have agreed to seek to expedite similar cases involving witnesses aged under 16 across all court divisions, albeit this will be done without having those really hard targets in place around the time frames that apply under the formal under-13s protocol. There's wider work which is also improving the experience of child complainants, including dedicated child-friendly rec facilities, the imminent launch of the child solas that I mentioned, and also work to improve ABE, or Achieving Best Evidence. ABE interview training has been improved with input from registered intermediaries, child psychologists and members of the legal profession. ABE interview suites have also been refurbished with children's toys and props available where they're required. There was a pilot of an ABE cadre that was run in the Southern Trust area, and that's proved really beneficial. However, further extension of that and rollout of it would need additional funding and resources. We are still working on other measures for child complainants, including work to pilot and to test pre-recorded cross-examination in cases involving young children. And on this, we would need additional funding to progress it, but it's not just contingent on funding. There are also some operational issues that kind of relate to the under-13s protocol that we need to resolve, and we want to get those resolved and addressed before we would then layer on a pre-recorded cross-examination pilot on top of that. And the Gillen review, as you know, also highlighted the benefits of a wraparound approach for children, such as the Icelandic Barnahus model. And we're continuing to work with partners across health, justice and the community and voluntary sector to scope options to introduce a Barnahus type model for Northern Ireland, with a view to identifying costed recommendations early next year. Other work streams are designed to deliver cultural and organisational change, again, to benefit victims, and this includes the development and rollout of a trauma-informed training framework for frontline professionals across the criminal justice system, and this is intended to enhance the understanding and the skills and the sensitivity of people in whatever role within the justice system who might be working with victims of sexual crime. Much of the work on the training framework has already been progressed. I think a key challenge for us now will be we can measure how much is being done. We want to measure what the impact of that is going to be. So we're working on a performance framework for that piece of work, and that's underway at the minute. Separately, in partnership with the Lady Chief Justice's Office and the Northern Ireland Courts and Tribunal Service, we recently published guidance for jurors setting out their legal responsibilities, including in relation to the use of social media during and after trials. So all sworn jurors are required to read this prior to the commencement of the trial, and then there's also posters that have been produced in there in all of the courthouses. At a societal level, we've been working with PSNI and the Executive Office to develop and deliver a campaign to tackle some of the underpinning behaviours and attitudes that can fuel sexual offending and violence against women and girls and gender-based violence more widely. And we anticipate that this campaign, it's a police-led campaign, but it is likely to launch early in the new year. Clearly there is a lot more work that needs to be done to realise the full vision that John Gillen set out in his review. I've tried to focus my remarks on those work streams where we're already beginning to see the outcomes in terms of victims and that are already directly improving the experience of complainants. The written paper that we provided to you set out a lot more detail on those, and also some of our the next steps that we need to take as well. I hope this has been helpful, and obviously we're happy to take any questions and try to answer those.
Really, thanks very much. First, anything Claire, Nigel want to add at this point, or just use completed? Okay, thank you. So members, just indicate if there's any questions that Ciara, yeah.
Well, thank you for your report, Julie, and the update, and for Nigel and Claire coming along today. One for me would be the Gateway Review recommended that the drafting of the legislation, the remaining legislation, would continue, and you're quite aware of the legislations proposed currently within this mandate. I would like some clarity on the main outstanding areas of legislation that you noted that needs to happen in relation to implementing the recommendations. So which of those legislative provisions will be introduced within this implementation period, given now the proposed to extend it, and what will happen to those that remain outstanding?
Yeah. I'm going to get Claire and Nigel to keep me right here, but so I've mentioned some of the legislation that we're consulting on already, including around clarifying the right for third-party legal representation, and that would allow us to expand the role of the SOLAs. In addition, there's policy work ongoing around consent, and we would hope to be in a position to include proposals on consent before the end of this mandate. There is other recommendations that were around jury-less trials, and some recommendations around judicial powers. Whilst, again, we will progress the policy work on those, it's unlikely that we'll be able to deliver that within this legislative programme, and that's partly about capacity issues, and some of the issues are particularly complex, and also some of the judicial, there's some of the recommendations around judicial directions, and there are other kind of non-Gillen pieces of work that also relate to judicial direction. So I think the department wants to look at those together collectively as a whole. And that's another part of the department that leads on that. So I'm not over the detail of it, but I think it's about Jenny had made some recommendations around jury directions, and it makes sense to look at all of those similar recommendations together. So that's something that I think is unlikely to be included in legislation within this mandate. The other thing that we're beginning to look at as well is early guilty pleas, so we're beginning to progress policy work around that as well. Is there any other?
Just perhaps there's a few recommendations around fee structures, particularly for sexual offences. They will hopefully be part of the Burgess review, Judge Burgess's review on criminal fees. So we hope to see that review soon. And Judge Burgess was liaising with Lord Justice Gillen on his recommendations. So some work on that is required as well.
A briefing on part of that after yourselves.
yeah.
So we'll put
Is
that
there
on.
any legislation that you're bringing forward of all those that you mentioned? Is there any that will be brought forward here to committee in this mandate?
We're working towards consent being brought forward, and those measures around the third-party legal representation. And then, whilst it wasn't strictly a Gillen recommendation, I think it's relevant. Is the proposals that we're currently consulting on in relation to the disclosure regime as well.
And just then on consent, can you provide me any further detail on what that actually means? What work are you ongoing are you in preparation for the legislation, consultation?
It's at the policy development stage, so it's kind of working through those issues, and it's something that the department wants to progress, but it has been a capacity issue that it hasn't been fully worked through at this point. So, but the intention is to work on that with a view to including in a victims and witness bill. So that would be where we would see that sitting.
And is there plans to remedy the capacity issue to be able to progress that work?
I think it is all about prioritising and looking at balancing out the priorities of that business area in order to be able to do that.
Thank you.
Thank you, Ciara. Connie?
Yeah, thank you for coming in today. Obviously a lot contained within that, and I think something I would really be interested to know around is sort of how you work with other departments. Especially I noticed that there's a recommendation around education, how you work with the Department of Education, but also how you work when you mentioned the campaign, the Party Change campaign, which you're launching next year, how that fits in with other pieces of work the executive is doing, such as the End of Violence Against Women and Girls strategy, but also the domestic and sexual abuse strategy, and how you make sure that work is cohesive and you can work together to achieve joint aims.
If I take your second question
Yeah,
first,
absolutely, yeah.
I think that part of Change campaign, I think it does. You're absolutely right. It cuts across the objectives in the Gillen Review, but also ending violence against women and girls and domestic and sexual abuse strategy, and it's been developed with that in mind. So it's been a PSNI lead, but the Executive Office and the Justice Department have been working collaboratively. In terms of domestic and sexual abuse strategy, I chair the Strategic Delivery Board for that. So I'm plugged into that work, and I can make sure that those alignments are there. And we're represented on the Executive Office's structures around ending violence against women and girls. The Executive Office is also represented on our domestic and sexual abuse strategy. So there is that through kind of internal contacts and through making sure that we have the right contacts and that we're communicating really regularly, and we are very regularly working with the Executive Office. The other department that we work really closely with on all of these issues is health as well, and there's really huge crossover with health and the domestic and sexual abuse strategy, but also on, say, Barnahus. So, and health will actually, they co-chair the Barnahus working group, so there is that really close working. On education, and I'm going to turn to Nigel, but there has been an education working group that has been cross-departmental and cross-sectoral. So,
yeah, whilst obviously RSE, Relationship Sexual Education, is led by Department of Education, we have a Gillen Education and Awareness group with over 30 groups represented on the group. Department of Education are represented, along with the likes of Nexus, Victim Support, the local universities, whole range of groups. And that group certainly has an opportunity there to speak to education representatives, give their views on which direction they see RSE going, and those are fed into the education representatives on the group. You will probably know education or consulting or have just completed consulting on RSE, so the group has fed into that. So there is a very, very close and active relationship with the Department of Education in relation to RSA.
But I think even on RSA as well, I mean, when you look at the strategic framework for ending violence against women and girls, again, there's like a massive read across there, and those interdependencies are recognised. And the Gillen review was published before there was such a focus on ending violence against women and girls, but it's really, I think both are really relevant. What we're doing in Gillen will deliver outcomes against that strategy, and that strategic framework will deliver outcomes that the Gillen review envisaged as well, and the idea is that they are mutually reinforcing, and that there is that respect agenda in particular that comes through in that RSA education.
If it's okay, Chair, just to follow up, if you could talk a bit more about, how often does that education group meet? Because, in the paper it only really referenced, the changes made by Chris Heaton-Harris, and that's really just about abortion and contraception. It's not really about consent. It's not about challenging rape myths. And do you think, how much progress has that group made? Does it meet regularly? And what kind of outcomes are we seeing from it as well?
We try to meet quarterly. Obviously, with such a large group, it's difficult to get meetings when everybody can attend, but we try to meet quarterly. And the group provides a forum for, as I say, all those organisations to provide input directly to the Department of Education. And I suppose from a Gillen perspective as well, there aren't any specific Gillen recommendations around RSE, but obviously in the report Sir John said that his wish was to see consistency and uniformity, and that has certainly come across in the views of the Education and Awareness Group. So say try to meet quarterly and whenever possible.
I think ultimately what is done within RSE is a matter for the Department for Education, but in addition to that work, there has been so the DOJ has done some work with police around rape myths. We've also funded Victim Support and NSPCC to produce a booklet which is around young people in crime, and I think flowing from that campaign that I mentioned, I think there will be like a first phase of that campaign which would be very kind of public level, and then I think the intention is that there would be then further work that and opportunities to work within school and youth settings and other settings that aren't specifically for children and young people as well, to kind of draw out what that campaign means for different groups of people across society.
Okay, thank you. I think that's really important, and it's something I think prevention is a space that a lot of us want to be in, and I think that consistent and uniform RSE that was spoken about in Gillen, I think is really crucial to that. So thank you for your updates.
Thanks very much, Connie. Morris?
Thank you very much, Chair. Can you hear me all right? Yeah?
Yes.
Yeah, and thanks very much for your presentation. Significant progress has been made, I would agree, as you have presented, and especially in remote evidence centres and the SOLA scheme. Could you tell me how many recommendations have yet to be implemented, and what has been the effect of a low estimated budget from the outset, and how has that impacted upon your work? Secondly, have any legislative changes which have not been implemented hindered the implication of the Gillen review? And have those impacts been severe, or can they be worked through? And finally, Chair, what is the impact of the Gillen review had on sexual offences and repeat sexual offences? Thus far, is there data collated on any success for benchmarking going into the future as opposed to looking back at the past?
Thanks, Morris. Yeah, go on ahead.
In terms of the progress, this is where my maths is really bad, so I apologise in advance. We said that we've got 77% of recommendations that are either fully or partially completed. So that equates to 58. So 195 recommendations out of 253 that are either fully or partially completed. By partially completed, that would include things like remote evidence centres or like the SOLA scheme, where we've taken it so far and it's really delivering huge benefits, but actually it's not fully implemented the full vision. So we include the partially recommended because we think that they're important and they are delivering significant change already. In terms of there are some legislative changes that haven't been done, and I set out what those were. In order to fully deliver the SOLA scheme, that would involve sexual offences legal advisors being able to represent complainants to the court at a pre-trial stage in order to help them to object to the introduction of their personal material or their previous sexual history. We're not able to, we haven't been able to introduce that yet because that will require legislation to clarify that right to third-party legal representation. So that's one impact. But we're planning to legislate for that by the end of this mandate. Consent, the legislation around consent will be around clarifying the law around consent, so that it's about clarifying and strengthening and putting beyond doubt, and that's something that we're planning to do by the end of this mandate as well. I think in approaching and in prioritising the work streams we have, as I said, we focused on where we thought the biggest impact would be in terms of benefits for victims. I think you asked about what the impact has been on sexual offending, and I think it's probably too soon to say because some of these are very new innovations. So remote evidence centres, I think we can see that there's where someone is opting to use a remote evidence centre, there's a high conviction rate, but it is very early days, and we would need to see, well, what is the impact of that over time on offending. The other thing you asked about was baselining, and one of the things that I think is really important and we're starting to do is to baseline attrition rates. So we haven't had those before. Nigel has been leading a piece of research looking at establishing a baseline for attrition in serious sexual offence cases, but also looking at, well, what have been the reasons behind. We can make, I think, professional judgments about what were the reasons for attrition in cases, but this is actually about trying to get to the data on that and then using that as a baseline to see over time, do overall attrition rates drop? Because that was one of the key objectives of the Gillen review, was to address this. So that baseline, that piece of research is due to report next year. It should give us a baseline, and then we can start to track, well, over time, what's the impact, and we would want to see those attrition rates going down. But certainly all of the measures that we've put in place, they've been about trying to support people to stay in the system, trying to take the trauma out of the system so that it's less difficult and less harrowing for people to stay in the system. So a lot, I think, of what you've asked is maybe a work in progress. I think you also asked about funding possibly, but I can't remember what.
Yeah, I was wondering what impact the initial budget from the outset, it was set pretty low, and what has that had on your work going forward?
So the initial budget was based on a strategic outline case where we were really looking at, well, what do we need to do in order to get this work started? It didn't take account of, and it very clearly and explicitly didn't take account of the cost of delivering a lot of the a lot of the measures because we haven't done the work to establish what things would cost. In some cases, we still haven't completed that work, and we're still looking. So, for example, the pre-recorded cross-examination pilot, we need to do some further work to look at what would that cost if we were to roll out the under-13s protocol and make that standard with those targets. We need to again cost what that would, and define what that would cost. So there is still some work and some question marks around cost. Again, we are doing some work around that. Nigel is doing work to develop an up-to-date outline business case, which will show us this is where we are, this is what we have, and here's where the gaps are. And I think in all of this, one of the big challenges has been that piece that I said about recurring costs, that nothing that very little within the Gillen review is a one-off cost. Most things are putting in place something that will have a recurring financial tail, and so you're not just looking at, do we have the money to do this in the here and now, but will we have the money to do it? If we're going to set up a scheme, do we have the money to sustain that scheme? So it is about looking at sustainability as well. And so when we've been progressing work, it has been in the context of prioritising what can we do and what are the best things that we can do to deliver the most improvements for victims with the money that we know that we have or that we believe we're going to get. If that answers or helps to answer your question.
It does. I'm happy that you are about to set a more realistic budget requirement, and you have done significant work so far. So well done, and thanks for the presentation. Thank you, Chair.
Thanks, Maurice. Justin?
Thanks, Chair. Thanks, Julie, Nigel, Claire, for your evidence session and for the serious amount of work you've already done. So thank you for your efforts. Further to what Maurice is saying and just following up on that and maybe further probing, what metrics, evidence-based and supporting narratives are used to monitor progress against objectives? And I guess fundamental to that is how many of the Gillen Review's 253 recommendations have been implemented and have not been implemented.
So in terms of the 253 recommendations, 195 of them have been either fully or partially implemented. 168 of them are fully and 26 are partially implemented. In terms of metrics, we have developed a performance framework for the programme. Now, some of this I think we need to look at over time, and we need to start gathering the data against that performance framework and seeing where that goes over time. I think with the Gillen Review, it is a really significant programme of reform, and reform doesn't just take time to introduce, but it takes time, I think, to turn and the curve on things. So I think that it will be really important to watch how we deliver against that performance framework over the next 2 years, 3 years and 5 years going forward, and see what the data does over that. We're happy to share that performance framework with the committee if that would be helpful.
I think so, yeah. I'd be interested to see that for sure. What's the likelihood of the Barnahus model being introduced to the North? And what's the likely timeframe for such introduction? I
think within the programme parameters for the Gillen programme, what we're looking to do is to scope what a Barnahus type model for Northern Ireland would be, and to develop costed recommendations. I think delivery of that would fall outside it would need a separate programme. Claire, do you want to say a wee bit more?
Sure. So Barnahus, as Julie said earlier, is a joint priority for the two departments, Justice and Health, because it's seen as incorporating all aspects of the child's experience when they're a victim of sexual crime. So we do work very, very closely. with them. So over the past kind of year, we've been assessing how far we are away from a Barnahouse and where current services meet the Barnahouse standards. So we've done a lot of work across all aspects of the child's journey to kind of see where we are. So that kind of benchmarking process has kind of showed where we already meet some of those standards, and we do, and you know, things like the Remote Evidence Centre are Barnahouse compliant without a doubt, and because they're child focused and make it easier for the child to give evidence. Things like the child solas that we're going to be implementing, things like the independent child sexual violence advocacy service, all of those are Barnahouse compliant, but there are gaps. And some of the gaps are things that we know about already, and that's delay, not just in terms of the justice journey, but also in terms of getting a child access to emergency therapeutic services, for example, as part of the health side of a Barnahouse model. Other aspects are data as well. We don't have that overarching picture of what a child's experience is like on both the health and the justice side from beginning to end, so we need to develop those. But I think it's shown us where we need to be to kind of come forward with costed, feasible options based on the progress that we've made with all of those elements already, but ensuring that it's geographically compliant. You know, it's all very well as having good examples in certain areas, but we need to ensure that children across Northern Ireland have access to the same high standards. So we've done a lot of work, and hopefully the next stage is coming together with these cost options and sharing it with stakeholders and bringing it forward to ministers.
When we were progressing work against the programme, we did consciously take a decision to look at developing things like SOLAs and remote evidence centres and putting in place those strands before then looking at, well, what's the model to weave them all together. So we wanted to have the services in place. But I think now we're at that point where it's like, well, what does the model look like?
And there is that scope for it to be different from being everything under one roof. We've seen that through study visits, that very few examples, everything happens under one roof. And there's even evidence to say that that's not the best model, is that you need to target it and have different flexible options based on what's appropriate for each jurisdiction. So hopefully that helps.
Thanks both for your evidence. Just on that, it's wonderful that you aspire to a Barnahouse type model, but it is worrying that you've identified yourself that there are gaps, and that's frightful for children experiencing the system right now.
Thanks, Justin. Doug?
Thank you, Chair. And Julie, thank you and your team for a really good briefing. I think sometimes when we look at this review and we sort of expect it all to be implemented, and it's actually really quite complicated in places. Could I get your sense, Julie, and you've mentioned it a few times, but I just get a sense of how you're going to fix the issue of third-person disclosure, the likes of from doctors or from counsellors, to make sure that the victim's not put off from coming forward, but the defendant also has the full support that he needs or they need to mount a defence.
Yeah, and I think that balance, I mentioned it in my opening remarks about the Gillen Review recognising that nothing that we do can interfere or compromise with the Article 6 rights of the defendant. So there is absolutely a balance that needs to be struck there. And we have just recently launched a consultation on legislative proposals to strengthen the protections for the complainants' private material, so including medical records, counselling records, etc. So that consultation is ongoing, and we will need to look at the responses to that and consider the responses to that. But Claire, do you want to talk a wee bit about, and you've been working with the Commissioner, the Victims of Crime Commissioner?
Yes, so this is one of Jerry Hanna's priorities, was really to tackle that disclosure issue, which is really putting a lot of people off. So the proposals that were consulted on, are currently being consulted on, are based on the existing judicial practice direction, which aren't statutory and are kind of difficult, and we know that they aren't being complied with, which leaves complainants in a kind of position where they're not sure that their material has been sought from a third party. So what we want to do in the proposals is to put in place strict requirements on applications for when defence are seeking those materials. So there will be objectives that they're required to notify the PPS, they're required to notify the complainant, they're required to notify the third party who holds the material, and then everyone's put on notice so that if the complainant wishes to object either to the scope, you know, it could be a broad request, but so we want to try and narrow those requests down so that they're specific and they follow an established line of inquiry. They can't be a broad request. There needs to be just a justification. So it gives the complainant the information that what's been sought, and then it gives them the power to kind of object to that, and that relates then to the other part of the legislation that we're bringing forward, which is to allow the SOLAs to go into court and actually represent those views pre-trial. So does that answer the question?
Oh, that's perfect, thanks. And it was just trying to get the sense of that really complicated juggling act that you've got to do, and I can see how difficult it is. First, can I just ask two very brief questions then, if I can? First of all, can I get a sense of where we are with minority groups on this issue, and particularly men, because it is being left behind, and I appreciate this is mostly women, but they are minority groups. And secondly, because I've been banging this drum on so many occasions, can you confirm that the victim and witnesses survey from this time onwards will start to include statistics from those who have suffered sexual violence?
You want to talk about the survey first?
Yes, I'm happy to do that. Yes, so the Northern Ireland Victims and Witness Survey has provided us with lots of really helpful information and feedback from victims over the years, and has, you know, it still does, but we've found that it's no longer getting the returns back that we want, and really there's a view that the methodology is no longer fit for purpose, and as you've said, it doesn't get feedback from particular groups, not just domestic and sexual violence, but also road traffic and different areas. So we're looking at the future for getting victim feedback, and obviously the Commissioner survey is part of that, so we want to work with her office. We also want to work with other partners who do their own victim surveys, and come up with, if we can, some overarching approach to make sure that we get representative feedback, you know, back from victims at every stage of the process, that we're not duplicating what each other are doing, and really hoping to realise some financial benefits from that as well. So we're working with the Commissioner and with all of the partners to see how we can come up with an appropriate methodology, and we want to do that at pace because we don't want there to be any gap in between where we lose sight of the victim journey. So we've got some plans in place to kind of map through how we can get to better data in future.
And I'm glad to hear that. And I did put that question to the Victims Commissioner, and she said similar. So I'm glad that is trying to come together in regards to that. So we have probably one survey which covers the full range of information that we can gain something from it. Thank you. And minorities?
I think you mentioned men as well, and I think there has been a lot of focus on women and girls, and I think that is appropriate. We know that women and girls are disproportionately affected by these kind of offences, but we also are very aware that it's not women and girls only, and also that victims of these offences have intersectional needs. I think the domestic and sexual abuse strategy is where we are trying to understand more about those intersectional needs, but also a lot of the services that we're delivering. It's that strategy has been developed really knowing that anybody can be a victim of domestic or sexual abuse. The services that are available, for example, the advocacy service, the SOLA services, they're available to victims regardless of their gender or regardless of any of their personal characteristics, and they will seek to provide tailored support appropriate to their needs. Also the 24-hour helpline that's available, that's on domestic abuse. So but I think we're in we're currently, the department is currently re-procuring for an advocacy service, and as part of that tender exercise, we have highlighted that we want the service provider to be delivering that service to people to meet their needs, and to look at, well, what are the barriers to someone accessing those services. So if they're male, are there things that they could do to promote that service to different communities, to different genders, etc., where we know that people may not find it as or may face additional barriers to coming forward. So I think that's a start. It's not all of it. We want to work with community and voluntary sector partners to look at, well, what are those needs and how do we meet them. The Commissioner has also done a piece of work looking at men and boys and their needs, and I think she wants to build on that as well. So there's work ongoing, and we will want to and need to do more work through that domestic and sexual abuse strategy to make sure that we are identifying what the barriers are to access and support, and the barriers to access and justice, and to one of the Gillen recommendations was for research into minority groups and around prevalence. That's a piece of work that we haven't yet started. I think it's again something that we're speaking to our colleagues about how we take that forward, but it hasn't. There are other pieces of research that are ongoing at the minute, and that's not one of them.
Well, listen, Julie and team, thank you. I mean, the Men's Advisory Project feel like they're sort of standing on their own a little bit, and in many ways they are, and they need support. But listen, thank you very much for that. Thank you, Chair.
Yeah, no, thanks very much. And I suppose just for myself, following on with Doug's kind of question, and the Gillen Review recommended that research into serious sex offences for marginalised communities should be carried out. Has that been done?
That's the one piece that we haven't started yet, and that we would need to look at our terms of reference and develop terms of reference for that. So there are other pieces of research that we have started. There are other pieces of work that have been done that aren't research, but that are kind of like reaching out to minority groups and minority communities to basically help people to see what supports are there, etc. And PSNI has led on some of that work, and we've provided funding for it to be done. But in terms of that piece of research on prevalence in minority groups, we haven't done that yet. We haven't started it. And
is that likely to be done soon? Is it in any of the immediate or forward work programmes?
It's not in an immediate forward work programme, and again, it's a capacity issue that we haven't been able to do that yet. But it's something that we will build into our work programmes going forward.
Okay, well, if we could be kept updated then on that, because I think it is an important area to touch on. Sorry, you said in your opening comments just around obviously the issue of delay, and it's part of a wider programme of work as well. And obviously some of the cases that have went through the courts recently in terms of judgments, the victims and survivors have come out, and one of their key frustrations is the delay and the length of time that it's taken. So I know you said there is work going on around the abolition of oral evidence in committal proceedings. But pertaining to this issue in terms of the Gillen Review, what other areas of work are being addressed then as part of that broader delay work programme that will link directly back into the review recommendations?
Okay, I can give you a really high level overview, but I'm not across the details because that's been progressed by another part of the department. But
could we even get a written follow-up on that, please?
Happy to do that, yeah. Okay. And I think the other bit that does fall within this programme is that under 13s protocol, which is judge-led, and is having a really significant impact on delay in cases in Belfast and Antrim involving under 13s, and the aspiration then to widen that out, and certainly the principles are being applied to all under 16 cases now. But without those hard targets being put in place.
I think it'd be good if we could get that right, and then just from that broader piece of work, that would be good. And sorry, you'd mentioned the children's protocol, and just I suppose it's being as a pilot in the two areas, and is that likely to be extended out, and if so, when?
I think Technically, it's no longer a pilot because it's been
Yes,
running for
it's
some
no longer,
time. It hasn't been formally extended out because of resourcing implications, but it has. So the under 13s protocol sets really quite hard targets, and there's a commitment to delivering against those hard targets in those areas. It's been done on a voluntary basis with no additional resource. To extend it out with those hard targets would require considerable additional resource, but there has been an agreement from all of the parties that are involved in it to seek to apply those principles to all cases across all core areas that are involving children under 16. I'm going to turn to Claire again.
Yeah, I was just going to say that the difficulty with, I suppose, progressing it out is that the under 13, obviously it's judge-led, so we're speaking about someone else's priorities, but it's, and I think they would all agree, the partners, it's based on a manual process. This is a specific cohort of under 13 with specific cases. So progressing them through the system from one end to the other relies on lots of kind of personal contact between different organisations. So I think as a department, before we would invest any money, we would want to get more data, and we want to get more systemic information, you know, on the process. And so that's one of the things we're looking at with the other organisations, and we're hoping to maybe bring a paper to the judge-led group in January, just with recommendations for how we think we can widen it out further.
Forward that assessment,
Yeah.
so that is,
Yes.
that has begun at least to assess it then?
Absolutely, yes.
Okay, no bother, thank you. The bit on the jurors' guidance, I was just really wondering, because you brought it up around, have there been issues then with jurors, and has there been a trend or anything in terms of the guidance, or is it just more best practice?
I think it's partly best practice, and it's also very specifically looking at social media responsibilities as part of that as well. You were part of that?
I was just going to say, given that the Gillen review came out shortly after the infamous Ulster rugby rape trial and all the social media issues around that, there were Gillen recommendations based on that trial. So yeah, the guidance for jurors just reaffirms what they're supposed to do, what they're not supposed to do, and as Julie said, it's provided to all jurors ahead of the trials.
And I suppose that's under constant review then as technology develops.
Absolutely, yeah.
Okay, no, that's brilliant, thank you. Was there anything else there? Sorry, I'm just checking here to make sure of nothing else. Yeah, I suppose the one thing come up constantly is the issue of resourcing and pressures, and obviously then prioritisation. So is there a resource plan built in terms of the resourcing that's there, and has there been a comprehensive, I suppose, impact assessment on that going forward and what you have prioritised? And I suppose as part of the transformation board, I mean, I know the department's put in pieces of work and I suppose investing to save. In terms of this area of work, are there proposals there that could potentially at a point in the future be taken forward where if the investment was put in, you know, there could be savings in terms of reducing delay and all of that?
I think certainly on the speeding up justice side, I think there's a lot, and I believe that they and that's the bit that I'm not over, and it would have separate funding arrangements, that speeding up justice programme. So there, so things like the committal reform, etc., and that they will be funded separately from us. In terms of the potential savings, I think from full implementation of Gillen, I think that they, you know, if you see attrition rates dropping, if you see people going through the system more quickly, if you see people being able to start their recovery journey more quickly, if you're appropriately meeting their needs, then I think there are system-wide savings to be had, you know, around kind of some of the well-being and needs that people have. So I think that there are opportunities there. In terms of our resourcing picture, we are working on an updated, up-to-date outline business case that sets out our gaps, and I think given pressures across the system, I think it is always likely that we're still going to be looking at how do we prioritise? But the next step for us is to define what the gap is.
So part of that business case then, that will look at an impact assessment in terms of the cost.
Yeah.
And when do you think that will be concluded then, in terms of the business case and stuff for?
We're looking at that at the minute. I think the business, the OBC itself, but not necessarily all of the supporting, the full impact assessment won't be done by this stage, but I think we're looking at kind of early January for that OBC to be completed, and then we'll need to be looking at that impact assessment, as flowing from that.
Okay, no worries. Any other questions, members? No, that's great. Just to say, Nigel, Julie and Claire, thanks very much for coming in. Appreciate your time and good luck in the time ahead. Yes, thank you. Okay, members, we're going to move on to agenda item 6, which is enabling access to justice reform programme, and refer you to pages 79 to 701 in your pack. It's pages 1 to 10 in the table pack as well in terms of relevant papers. And just to advise that we will have officials in from the department who are going to give us an overview in terms of the different sections that makes up. We're going to have, I'll just wait till they come in. Yes. Okay, members, we have joining us for this evidence session Stephen Allison, the Deputy Director of Enabling Access to Justice Division, Brona O'Reilly, Programme Manager, John Bradley, Head of the Civil and Legal Aid Reform, and also Chris Barry, who is the Head of the Taxation Review. So you are very welcome to the Justice Committee. I'm just going to throw it open to yourselves, Stephen, just for your opening statements and comments, and then we'll throw it open to members afterwards.
Thank you, Chair.
Thank you.
I'll keep my remarks very brief. Conscious about a lot of papers. So good afternoon, Committee and Chair. Very grateful for the opportunity today to brief the Committee on the Enabling Access to Justice, and in particular the associated delivery plan. And can I also take this opportunity to thank the Committee for enabling us to come today. I know there was a bit of a last minute change, so thank you for arranging that, and any inconvenience. Apologies for the inconvenience. As you say, Chair, I'm joined today with my colleagues Brona, John and Chris. When we last appeared before the Committee in May, we outlined a range of reviews that were ongoing to inform the development of a reform programme to enable and enhance access to justice. And this included the call for evidence that was launched in April of this year and concluded in July, which we got a significant response to. The independent review at that point was ongoing, commissioned by the department and led by Judge Burgess. That review concluded on the 23rd of August with Judge Burgess presenting his report. Other inputs to the reform programme, the ongoing review of taxation, that's been led by Chris and continues to be taken forward. Benchmark on exercises and reviews of various other data sets. We've set that out in various reports. In addition, because we didn't mention this, because we didn't have this in place when we last spoke before the Committee, in late July we jointly commissioned a review alongside Geraldine and Helena, the Victims Commissioner Designate, a review led by Ulster University, Professor Langdon and Queen's University colleagues, just to inform a rapid priority setting exercise to help us what should we focus our time and energy on to support domestic abuse victims further. And a copy of that report is also in the pack we provided last week. I'd like to put in record my thanks to everyone involved in participating in all of those reviews, from the academics, the legal profession, the voluntary sector, all of the organisations that presented lots of evidence for us, and in particular the individuals who have gone through the system as victims, defendants, survivors, witnesses who contributed to that. I'm conscious that we have provided you with a large volume of information. That information it's a distillation of all of the information that we have received. and it has informed, and taken together, that's informed the development of our programme and the associated prioritised delivery plan. As we set out in the written briefing, we plan to issue the delivery plan next week for public consultation, and essentially that consultation is essentially asking society's views on the running order, the sequencing, to help us understand how we got the right running order. The example I would give, Chair, is I don't want to flood public consultations in one quarter so that we don't get qualitative information. The voluntary sector and organisations are stretched, we appreciate that, so I don't want our plan setting out 5 public consultations in a quarter that they might say, well, spread that out a little. I want qualitative information to inform our policy. We do consider a strong case for reform at pace in the interest of enabling access to justice and in view of their increasing pressures and the need to ensure sustainability. To that end, we're inviting the committee to agree an 8-week consultation period for the delivery plan, because it is simply on sequencing, not necessarily content, because each of the proposals in the delivery plan will be subject to their own discrete, specific consultations. We recognise that the reform programme is ambitious, both in scale and pace, but we think it's realistic ambition, subject, of course, to the usual caveats of funding and resource availability. I did promise a short opening remarks, Chair, so I think it's probably an opportune moment to say thank you for the opportunity again, and open yourselves up to questions.
Yeah, no, thanks very much for that, and I'm going to throw it open now to members, if you just want to indicate. Anybody there at the moment? Oh yes, Doug, go on ahead.
Sorry, apologies, Chair. Thank you for the short brief. I had a look through most of the Burgess report and tried to understand it as best I could. I have to say, I find the whole legal aid piece extremely complicated. But look, it is what it is. But I looked at some of the recommendations, and the recommendations of it increasing remuneration by 16%, refreshers fees by 25%, King's Council 25%, travel allowance being increased. And considering we have a legal aid budget of 114 million this year with a population of 1.9 million. Scotland, of 5.5 million population, has 151 million in legal aid. All of those increases in fees that have been recommended, and they've asked for them to be put through at pace. Do we know how much that would cost? Has a bit of costing done on that element of it?
Yes, there's been a high level costing. So we are applying. We're not moving beyond 16%. So one of our reports, we're setting out what we've accepted and what we haven't accepted. To be fair to say, I think in terms of the fees that Judge Burgess has recommended, we've accepted most, either in full or in part. We've extended that, as the Minister set out on Monday, to widen that not just to criminal, but we feel it's important that we also address concerns on the fee structures for civil and family. The high-level estimate at this point in time will be about £9.5 million for that uplift. But the business case, Mr. Beattie, will be on a programme base, so the totality of the programme, there are areas that we would be looking to amend delivery mechanisms, potentially amend scope, the certification process. So as the themes of the programme suggest, there is one key theme in terms of managing public funds and a number of actions there that we look to put controls in place to try and target the spend to the most vulnerable, because that's the clear message I certainly want to impart today. I want to protect the most vulnerable in society and give them access to justice. So in short answer, it's about 9.5 million high level, and that will be distilled further as we go through the business case. We're working with finance colleagues at the moment and the Department of Finance to move that forward.
Yeah, and Stephen, just so be absolutely clear, I'm with you on this. Those who need access to justice and need legal aid, it must be there and it must be available to them. And it's part of that value for money piece that's certainly in the report. But also within the report, it said set up a working group with an independent chair. projects to be undertaken, legal aid advisory board, and setting up a code as well. How many of these recommendations are you likely to take on board?
If I could break those down, Mr. Beattie, in terms of the working group to look at creating data and also then using that data to inform fee structures, as Judge Burgess set out, we're taking that in two parts. The first immediate part is there is an absence of data to inform the evidence base for reform of fees at specific levels. There's certain parts of Judge Burgess' report he's saying I didn't have data, and therefore this needs to be moved into a different space. So one of our first priorities in the new year is to establish the reference group to identify, start collating and validating the data. That will be chaired by either a statistician or an economist from within the department, because it's about data. They know that better than I will do. We haven't ruled out entirely establishing a working group after that, led by an independent chair or other, but we want to get the reference group. Let's get the data. Let's see what we're working on. In terms of the Legal Aid Advisory Board, we have taken the view at this point, well, we need to step back because there's an awful lot of oversight at the moment across the justice system, whether it be Criminal Justice Board, programme boards for all of these, and also Shadow Family Justice Board, Shadow Civil Justice Council. So before we establish another body, we want to step back and go, where does this all fit in? Can we look at that? Is there overlaps? So we haven't ruled it out, but we're not sure about just where that fits into the landscape at the moment.
Thank you for that. And I have a tendency to agree with you, and that's why I raised it in the manner that I raised it, because it seems to be adding more layers on top of layers we already have in place. And even if I look at the working group with an independent chair, it's recommending that gets set up. But in the meantime, without the recommendations from the independent chair, that we go ahead and increase the fees and to do that at pace. Can I just ask that last bit on the fees when it says do that at pace? What time frame are you looking at doing that? You know, because it does say in the report to do it as quickly as possible. Do you just have a time frame yet?
We do. In the delivery plan that we're setting out and seeking to consult, it is subject to funding, so we still need to, in parallel, pursue that. I have to say that because if we don't have the funding, we'll have to pursue that. But in parallel to that, and along with the legislative timetable, if we get everything in place, we're planning to issue proposals early into the new year for public consultation. They'll be obviously presented to the committee for scrutiny beforehand in terms of consultation document. 12-week period for consultation. It's supported. We need to amend legislation, but it's supported legislation. With a fair wind, if all of the dominoes fall in the right order here, we are looking at April or May to enable legislation. If the funding is made available by that stage, we can then introduce those new fees by April or May of next year.
Perfect. And a very, excuse me, Chair, just a very, very quick one then. So are those people who affects the most, those who deliver the legal aid services, are they reasonably happy with that figure of 16%? Where's it been generated from?
It's a difficult one for me because we've obviously only published the report on Monday of this week. I'm due to hopefully meeting with the Law Society and the Bar next week, which is subject to diary commitments, and we'll get a better sense check on that. I would hope that it'll be recognised that Judge Burgess has recommended 16%. He has an evidence base that we feel provides a good persuasive case. We've added some evidence to that to try and get the argument over the line. So the basis is 16% is what Judge Burgess has suggested. Some of the other areas where he suggested 25%, we're saying, look, we'll go to 16%, but we need evidence to support the difference. So I'm not able to say at this point what the sense check is from stakeholders. That's in front of me next week, and I hope that they will see that there's an absolute willingness to look at the report, give it the best possible run on it. But it does come down to can we secure the funds.
Stephen, thank you, and thank your team, and thank you, Chair, for your indulgence.
Thanks very much, Doug. No problem. Justin? Oh, you're on mute, Justin. Sorry.
Thanks, Chair. Hi, Stephen, Brona, John, Chris, thank you for your evidence. In terms of access to justice, a social worker visited my office this week and outlined her concerns in relation to what she sees as being a troubling issue in terms of the huge amount of women engaging with social workers who are being subjected to coercive control, domestic violence, abuse, domestic abuse and harassment at the hands of a partner or ex-partner, but who have no means to pursue a non-molestation order and who do not qualify for legal aid. These women feel like they're being left without any recourse for justice. Can you outline what assessment has been undertaken by the department on this front to gauge how many women are being affected by this issue? How does this factor in the Minister's commitments to enable access to justice?
Mr. McNulty, thank you. And I would have to say, in our conversations with Women's Aid and other organisations and their submissions, that point has been really well made, and we have taken that on board. So the delivery plan is focusing on and has identified a number of vulnerable groups that we have to look at the structure of legal aid, the eligibility thresholds, the application process, that we can actually make sure that someone gets a decision that legal aid is available to them at the most vulnerable point in their life, that we can support them as quickly as possible without the bureaucracy that I will freely admit exists at the moment. I'm not sure, I'll check to my right with John to see if there's any answer to the question in terms of what figures we have here. But in global terms, this is an area that we want to focus on. We want to make, and we've very clearly set that in the delivery plan, that domestic abuse victims are a group that we want to build and develop further protections into the legal aid space in terms of eligibility. An example perhaps being, if you get some people in the domestic abuse space, in our experience, will move to criminal space, will also be in civil and family orders, whether it's children looking for help on support for housing or so forth and so on. We want to get to the point you make an application once for legal aid and that passport's due through. You don't have to keep doing that if you're in that space. So it's quicker, speedier. I hope it'll also help the profession that they're not spending as much time as they have to at the moment putting the application process together. I'll stop there because I promised to cross to John here in case he can give you more detailed metrics.
Well, metrics perhaps, but 2 points probably I'd like to make, Stephen. One of them is that we have heard consistently that the current protections in the access to justice and legal aid system are not adequately addressing the needs of domestic abuse victims in all cases, and that there's therefore a strand of work in the delivery plan that looks specifically at what additional supports we can usefully put in place for those people. The other point I'd like to make, because I'd like to make it as often as I possibly can, there is in existence a waiver, a discretionary waiver available to the Legal Services Agency to set aside a person's means when they're applying for representation to seek a non-molestation order. And that waiver is granted in all circumstances where someone seeks one. So anyone who needs a non-molestation order, regardless of their means, will be eligible for legal aid to pursue it. The uptake of that waiver has been poor, consistently poor, because people aren't aware of it, and people are therefore often paying privately for non-molestation order proceedings when they need not. So as things stand, if someone is otherwise ineligible for legal aid but needs the protection of a non-molestation order, they can get a legal aid certificate for representation. They will be liable to make some contribution towards their own costs, but it'll be substantially less than the cost of paying privately. But as I say, these protections haven't addressed the needs of all domestic abuse victims. We've heard that consistently through the call for evidence and through the priority setting exercise. So we will have a strand of work beginning at an early stage in the delivery plan where we will go and speak directly to those working in this sector to seek to design additional supports to better meet the needs of domestic abuse victims.
I could just add that, Mr. McNulty, I accompanied the Ministry yesterday to OMA, where we met with solicitors associations from OMA, Enniskillen and Strabane, and a really informative session, but again, just resonating with what you're hearing from your constituents. No molestation orders, difficult process, challenging, and it was helpful yesterday because the solicitors have agreed yesterday to start developing some metrics around how long is it taken, what are the difficulties, and I'll engage very quickly in the new year with those solicitors again, help us develop the solution together here. So we're very alive to this issue. We want to protect and support the most vulnerable at their most vulnerable point in their need. That's a major thrust in this programme.
Justin, anything
Thanks,
else?
folks.
Thank you.
Thanks, folks. Somewhat reassuring, but alarm bells have been ringing here. We need to address this issue. So thank you so much.
Thanks very much, Justin. Kira, you want to come in on this point, the last point by
I'd just
John?
like to come in on that. I myself as well, and speaking to many women, if you went through the process, but also speaking even as of yesterday, doing a visit in the courthouse and speaking to some solicitors. Not only am I gravely worried about the reduction in the number of solicitors that will even provide a service when it comes to legal aid, and we know that is becoming dire in some areas. But the waiver was also something that was mentioned, and you had mentioned maybe lack of awareness, but I'm finding it's the opposite, is where it's not worth the paper it's written on, because the length of time it takes you to complete the paperwork in relation to it, it's not cost effective.
Yeah.
And then, you know, so it would be really, really useful. I'm glad to hear, Stephen, that you mentioned, you've highlighted that as well. It's something that you are looking at, because there's no point having a service when it's not worth a solicitor spending 4 or 5 hours on for the amount. You know, it's just.
Absolutely. And there's a separate strand of work in the delivery plan that's looking at simpler and fairer eligibility rules in general.
Yeah.
Because I think the application process, whether for domestic abuse issues or generally for legal aid, is, we are aware, acting as a barrier to people getting access to those services. So I think, yes, both in the case of domestic abuse victims and more generally, we'll be looking to try to improve the systems to knock some of those barriers out of the way for
It's
people.
more around the administrative side of stuff.
Absolutely.
And I know you obviously have to ensure value for money, and it's public money, it needs to be accountable. But if the work that's required for that piece of information is not covered, it kind of defeats the purpose of having a waiver. So despite the fact, so I would be concerned that you may increase people being aware of a waiver, but you'll have no solicitor actually helping it to be complete and sent in, given the scale of work, and it's not cost effective to do it. So it's just, I just wanted to highlight that again and reiterate it, given that it was raised by myself.
It's very helpful because it does resonate with us. I mean, I think as when we're looking at all of our systems, we also have to look, when we're talking about ensuring value and value, we also have to look at how much is the input cost to actually deliver that. If it's costing X amount more than actually the benefit, we shouldn't be doing it. You know, I think we can, as John says, there's an ambition to absolutely simplify the process.
Yeah.
We shouldn't have solicitors spending half an hour sitting going through forms at the expense of giving advice. But equally, there's a balance. We need some sort of qualifying metrics and criteria. But the ambition definitely is there to simplify it. It has to be. In this day and age, we should be able to simplify that.
I think it's a key point. Sorry, just to before I bring Jem in, because on the one hand, barristers just submit a fee, where solicitors have to go through all of these different hoops then. And it's, you're right, how we can streamline the process to reduce the admin burden, obviously still be accountable for public money, but just to streamline it a bit more. Gemma?
Thank you, Chair, and thanks to the officials for coming in. Now, this is my first Justice Committee of this mandate, so please bear with me. I'm just looking for clarification, and just if I pick this up right. So, are you saying that you're setting up a body in the new year to collect the data, and then a working group in 18 to 24 months to analyse the data? Is that correct?
No, I mean, we're saying our first priority and the one thing we're working on is let's get the data sorted. I think after that, at some point we can look at, well, we're going to have to make a decision on, as part of the reform programme anyway, we've set out, we need to look at the current review mechanisms. We have some statutory obligations to do reviews. I personally don't think that they function that well. We spend more time debating scope and not actually doing the review, at the detriment of actually making a difference. So I think, Stolan, the simplest way to answer that is the priority is to start collecting, identifying data that we can all agree is relevant to inform decisions. Start collating that in a way that the statisticians and economists can help us build the case. And then, as we're going through that, we can then start separately look at, well, what's the best way to actually work together to use that data to inform decisions to make the case for change. So we haven't ruled out a working group, but we're not establishing a working group chaired by an independent at this stage. We're creating a working group, reference group, just to collect the data, to get into that space, because that's the urgent need. You know, if we were to create a working group now, what would they be working with? No data. They'll be sitting waiting for this other group to come forward with. So priority is working with stakeholders, working with the profession in particular. Let's get around the table and identify the data that we need, what's relevant, what's not relevant, what's available, what needs to be built and created and collated, and how are we all going to be satisfied it's validated and absolutely robust. How we use that data, I think, is a separate discussion further down the year.
Right, okay, but it will be just further down the year, it'll be later on next year, is that right?
To me, it's one of those chicken and egg questions, because the quicker we can get the data, the quicker we can move into the using it. So if we can coalesce around data and it's really relatively straightforward, I wouldn't want to be perfection being the enemy of the good here. If we can get data on certain areas and we can move on it, we do that. I'm certainly not going to wait until the end and we've got the perfect bundle, because there's no such thing as perfect data.
Yeah. No, that's perfect. That answers it. Thank you.
Thank you.
Okay, thank you.
Can I just
Jim,
come back
or
on the
Ciara?
data? What data are you looking for? What data sets will you be using in your analysis? And is there any challenges to accessing the data that you would really want to require to have a robust baseline?
I think we'd accept, in terms of what types of data, at the moment, we'd like to understand, well, what are the input costs for solicitors and barristers? What's their input costs? What are they trying to cover in terms of running their firms? So what is the hourly rate? There's some evidence there, because we have to pay a fair rate. What are we asking them to do in the system? How long do each of those transactions take? So let's understand, well, what's the ask? What are we asking? So if you're in a magistrate's court and you're making an application for bail, or if you're running a defence on an assault case or a murder, what's the points of distinction? What's the time frame involved in that? What are the building blocks to actually the work? And then translate that back to, well, what are the input costs? What do we need to pay there as a fair going rate? But in terms of the barriers to that, we've said before in terms of brief fees, I still have no idea how a brief fee is made up, and we'll continue to engage with the bar to understand that. But it's very difficult for us to create a fee structure if we don't know the underpinning blocks. I'd like to understand from solicitors exactly what's involved in their area. We have lots of fragmented data, but I think we need to come together and go, rather than arguing about what's relevant, because we spent a lot of time over the last couple of years in previous reviews, to be candid, and I'm sure it would be fair to say, I would imagine that the professionals will say the same. It's at the detriment of actually getting on that we don't agree what a relevant data set is.
Do you think you'll? I'm just conscious of the taxi master at the moment in time, and earlier on we were made aware of the 1978 Act that set forth the tax master and their role, and then we subsequently had the 2014 Act, which was to look again at legal aid and change it, and nothing happened, and we're now 10 years on, and you're looking to see if you can get the right data again to see how we actually do the charging. So I'm just conscious, particularly since 2014, and it never happened. What's the confidence that's going to happen this time? What are you doing different? What's been done differently, or how are you going to go about it? I just can't get my head around the taxing master, independent, know the profession, know the work that's done, does that assessment. What information are you going to receive that's different to what the tax master already utilises?
Well,
is it?
I'll invite Chris in a second, because Chris has done all the sterling work in the last 12 months and that. So what's different? Easy to answer is, for the first time, we've been able to, through good graces of the taxing master, the previous taxing master, we've got access to the files that the taxing master gets, the bills, the brief fees, what's sent in by solicitors. We've never had that before, because it is an independent function and it's not a criticism. So in the last 12 months, Chris and his team have been able to go down. I'm really grateful to the taxing master for doing that. I'll let you speak to that in a second. So that's a big point of distinction, because we've got real granular data. We still, in that granular data, have brief fees coming in from barristers that would like to understand, working with the bar, well, what are the building blocks of a brief fee? Because if we're translating that into a standard fee structure, an hourly rate function, it would be important to understand, well, what are they building in? So that's the biggest point of distinction on the taxing master.
And sorry, just to cut across you, but does the taxing master not have that already when he is actually assessing it, and he reassesses and would make deductions if he thought it wasn't appropriate? So what's he been using? Well,
to be fair, that's the only difference there is the taxing master receives the bills from the solicitors, the brief fees. they will make the assessment and have made the assessment. But when we get the final bill, the order to pay, we don't have all of those backing papers. We haven't had access to those before. So now
Do you have access to how he assessed his?
we
have. Do you want me to come in?
Yeah,
As Stephen,
the expert in this area, so
I'll go easy on me. As Stephen has said, we've now had a greater insight, I think, into the current process as it operates. I mean, the thrust of that was, before you start to reform something, we want to understand what is the current position as best as we can. So we have got down into the Tax and Master's office. We have been able to review the documentation that is submitted to the Master. What I would say is, solicitors, as you will know by now, there is a more detailed bill of costs provided by them, and they break everything down to the hour. So we can see, and we get that on LAMS. It's a resource intensive exercise, and that's what I would say about the gathering of the data. It's not just the data, I would say it's also the quality of that data, the accessibility of that data, because at the minute I have a small team and it's taken us quite a long period of time, but it is a literal trawl through page after page of bills submitted by practitioners. So it's about, can we look at what the position is now? Is that fit for purpose under how we would do things under managing public money, accountability and transparency? If it's not, what can we do to make it better, to make it more transparent and accountable, and take it from there? So that's what we've been doing. And as I say, it's about that quality of data. We know more now. But for example, as Stephen says about the brief fee, we now have seen council report on cases, but that's a narrative report on a case. It involved these complexities were at play. There's no breaking down of the work the way a solicitor would. So it's would we replicate that? I would say that would be very difficult to replicate if we were reforming the system to take that under the purview of the accounting officer. Would we replicate the solicitor uplift, which is in play at the minute, whereby yes, they break everything down, but at the end of the day there's a 33, 40, 50, 65, 150% uplift, which is their profit element of what they've done. You know, the hourly rate is there to cover their running costs, their break-even point, if you like. The uplift then comes on top of that, and that's the profit element. Would we replicate that? So that's what we've been doing.
Given the task, have you a time frame where you would hope to complete the task, so you have a baseline of?
In terms of taxation reform, the delivery plan will show that we are aiming to consult on proposals in relation to High Court bail applications in March of 2025. We are then taking forward a look at judicial review remuneration and criminal court of appeal remuneration, and we aim to introduce proposals in relation to those areas for criminal court of appeal December of 2025 and judicial review March of 2026. And there are three elements. Taxation then will cover and does cover a whole range of other types of cases, but these are the three that we've identified for the purposes of the remainder of this mandate, where we think we would have a good opportunity to instigate reform.
Well, thank you, Chris. Thank you.
Ciara, yeah, thanks. Chris, just following on from that, because obviously this is an issue that's beginning to emerge and a concern, and obviously in terms of the first Justice Bill and aspects of it. So I'm keen just to see what engagement there has been with key stakeholders, because on the one hand, I suppose on one view, it's nearly like a power grab by the department in terms of trying to take this in. So it's just to see what engagement you have been having around what it could look like. I mean, you had said, Stephen, that the Tax and Master as it currently is provides an independent function. So if something was to come into the department, I mean, it can get in one hand to understand the data and the figures and how that's made up, because that would be questions that I would ask, and the fairness between the different sections of the legal profession in terms of what people are required to do to draw down their expenditure. So, but in terms of, you know, your analysis going forward and looking at this role, how do you still ensure that there is that level of independent function, or do you even see that would be the case when it comes in, and what protections potentially would be built in? I imagine we're going to probably pick this up in the oral sessions get into the new year as well, but it would just be keen to see from the work that you've done now and the level of engagement, if any, that you've had with interested parties and stakeholders on this issue.
Yeah, sure. I mean, we've engaged with the Lady Chief Justice and the Taxing Master. Stephen and myself are actually meeting with the Taxing Master next week. And as we've alluded to before, we've had a good relationship with his office and getting down there and being given information that we haven't previously had access to. We've also engaged with the Bar and the Law Society. We've had useful engagement with the Law Society, specifically in relation to High Court bail. We've provided them with data that we have gleaned from our work. We've held a round table with them where they were able to make some useful suggestions as to what we might go away and look at in more detail. We haven't had the opportunity to do that yet with the Bar, although we're trying to do that. And we've also engaged, there's other stakeholders involved here. There's cost drawers who are involved in the drawing up of these bills of cost that solicitors provide. This is obviously going to be a concern to them. We've met with several cost drawers and we're keeping them appraised as we go forward. And as I say, we've met with the courts, with LSA as well, because if this is something that comes within the LSA in terms of an assessment rule, they need to be geared to do that, and we need to make sure that anything that we come up with has it's being able to operationalise it and making sure that they're in early to be able to help shape that, as well as the professions and everybody else involved. You'd also mentioned about the independence, and the Taxing Master is an independent judicial figure and routinely reduces bills that come before them. There's nothing new essentially in what we're looking at, because this has been done in other areas. You know, the criminal court, the Crown Court has a standard fee regime which would have been previously assessed by the Master. The Master retains an appellate role in the Crown Court, so if the LSA assess and the practitioner is not content with that assessment or disputes that assessment, they have a route to appeal to the Taxing Master. We don't envisage anything different with regards to taxation reform of not retaining some of that. You know, it's about having the scrutiny and the transparent process for assessment, but if practitioners who go through that aren't satisfied, they have recourse to an appeal function, and we don't imagine that there would be any change in that.
I'd say, I mean, subject to discussions with the Tax Master, Lady Chief Justice, but I would hope that the Taxing Master's role in terms of the appellate role is maintained, because that does provide that independence, and it's an avenue for appeal if someone's unhappy with or unsatisfied with the internal assessment.
Okay, thank you on that one. The other issue, sorry, I was going to ask, and you've kind of answered it, Stephen, was the delivery plan going to be made public? So I know you touched on, and even in the Dallows letter to the committee, touches on a consultation period. So are you hoping, that this is published, is it for next week? And to start an 8-week consultation? Okay, and I suppose you've figured in, I suppose one of the issues that have come up at committee has been consulting over Christmas periods or periods like that. But are you satisfied that 8 weeks then, considering that we're getting into the mouth of Christmas now, is adequate in terms of the sequencing of the reform programme overall?
I think so, because we're also going to commence some of the reform options that's in the programme.
Yeah, further consultations.
As we're going through, so we're not trying to do a domino effect, because we really want to get into it. But our questions that we're asking in the consultation, Chair, are simply on, it's not on, do you think we should be doing this? It's, are we doing this in the right order? Because, to be candid, the reform programme has been heavily informed by the call for evidence of what people have already told us. So it's as I said earlier in the session, we really want to make sure that people are given a chance to say, organisations are given a chance to say, well, look, that doesn't sort of sequence, doesn't work for us. Why are you doing it in that one first, not this one? As importantly, don't send 5 of those out in that quarter, because we're not going to get a chance to give you a response. Yeah. So the short answer is, I think, given the discrete nature of the consultation, 8 weeks, I think, will be more than.
And I suppose, as you say, there's strands of it when you look at the delivery plan that you want to start hitting quarter 1 and 2. And I suppose by the time you assess the consultation responses, I suppose, will you just highlight to the committee in advance of any of those being going live, any of the responses coming in, even if the report isn't fully completed, any concerns or supposed support for the programme or elements of it? Will you update the committee on that?
Very much, sure. I mean, this, as we said in the written brief, it's really important, certainly for me and my team, and certainly for the Minister. This is the first time we've surfaced the delivery plan, and we will keep the committee updated as we progress. not least because we want to hear your views, but also not least there's an awful lot in that delivery plan that will then come coming before you in terms of consultation proposals and subsequently potential legislative amendments, and we want to give you a fair wind on that.
I suppose that's a bit we're looking at, particularly around maybe taxation elements that are going to be in the first Justice Bill. We're doing the call for evidence and stuff as well, so which is another engagement piece. The other bit, sorry, was just around, I suppose just to feed into that point, it was to highlight, I know Joanne as well, who's not here today, the chair's not well, but I suppose we are aware that stakeholders were told that you were coming to brief the committee in person in advance of us being told. And I suppose just to highlight that as an area of concern. No problem with stakeholders being engaged. I think that's a good thing, but I think just to give the committee their place in advance. But we are glad you are here. The other bit, sorry Stephen, it was again just on the legal aid, and I know in the delivery programme, I mean obviously, you know, there has been noises around the Burgess review, elements of legal aid, looking at the interim payments and stuff as well. We've obviously got correspondence in our pack today, and I know that's been sent to the Minister first, and then we have been kind of CC'd in on it as well. But you had said around obviously doing a 12-week consultation in terms of, is that on the interim payment? And you had said around potentially introducing fees in April and May. Is that introducing the mechanism, or actually that would start to be paid, and is that dependent on the budget and stuff for next year, or have you costed that in? So just a wee bit more info on that.
The timetable for April and May is the enabling legislation to be completed and in.
Okay.
And once the enabling legislation that has those new fee schedules in place, that's then in play for any new cases that come onto that from that date. Those fees will apply. But that is contingent upon the funding underpinning that. If the funding's not there, we won't be able to bring forward that legislation.
Have you like a ballpark figure of what that's going to entail, or in terms of obviously we're going through the budget process at the moment for next year's budget?
So as I mentioned to Mr. Mead, I mean that figure for in terms of the totality of the uplifts that we're looking at, including the mileage and the interim and refresher fees and so forth, we're looking at about £9 to £9.5 million. Now that's high level, and that we will progress that through, and we are working, but that will be an ask from DOF colleagues and the Finance Minister in terms of a very detailed business case. We think we have a very persuasive case, but whether that's in the current climate going to get funds.
And I suppose just as I touched on, we have got communication, which I know went to the Minister first, so has there been ongoing engagement with the key stakeholders then around this? Obviously, you know, there was protest action there, I think it was a month ago, and obviously there could be the potential of more depending on the sequencing. So it's just to see what engagement there has been and there will be over the next short period.
There has been engagement both at ministerial level with the Bar Council and the Law Society officials and various associations, and that was followed up by high-level briefings in terms of explaining where we were going and what may be coming through at very high level, and what the shape of the delivery plan in terms of themes may be. I spoke on Monday of this week and Tuesday of this week with the Chief Executive and the Deputy Chief Executive of the Bar and the Law Society respectively, to see if we can get a date in the diary next week.
I've seen that on the
and also just in terms of to take their advice, because the Bar and the Law Society and themselves are organisations, but the Solicitors Criminal Bar Association, as I understand, it's an independent organisation made up of about 60 or 70 firms. So I'm wanting to take advice in terms of what way do you want me to engage, what's the best way, because I don't want to be creating any divisions within the society themselves. I don't think there are. I just want to make sure I'm landing in the right way. So just waiting for diary date next week with the Law Society and the Bar.
Okay.
So we do want to get into the space of trying to, first of all, on the delivery plan, but also the reference group, and then starting to engage not just with the Law Society and the Bar, but also all the other key stakeholders that will inform this shape.
Okay, and sorry, on the delivery, what have you a day in mind yet for when you're going to go live on that public consultation and making the report public?
We're hoping to do it early next week, and the reason I'm ambivalent is we're wanting to make sure the delivery plan is accessible in all formats, so we're doing all the double checks.
By next week anyway?
Definitely by
early next week.
Very early next week.
Okay.
It's just we're doing the final checks and double checks to make sure it's accessible in all formats.
No bother, that's fair enough. Any other members? Any questions? No, I think that's us for now, and I suppose we'll keep in contact then as you go through each stage of this. But again, thanks very much for coming in.
Okay.
Safe home. Hopefully the weather's not too bad out there. But
Has calmed down.
safe travel.
Thank you very much.
Thanks very much. Okay, members, we're going to move on to agenda item 7, vehicle recovery, storage and disposal, statutory charges review. So just refer you to pages 702 to 717, and to advise you that this is a written brief from the department that provides an overview to responses and proposed next steps following the department's consultation on the statutory charges. Just to remind you that at our meeting on the 11th of April of this year, the committee noted a paper from the department on vehicle recovery, storage and disposal charges. We agreed to consider the matter when the results of the consultation and proposed next steps were available. And at the same meeting, we also agreed to write to the department to ask whether a comparison had been made between the cost of the charges here in the north and also those in the south of Ireland, and whether the charges had been detailed, covered the full cost of vehicle recovery. The department provided the requested information and the committee was content to note the response. So again, I'm just asking if members have any views or questions on this, and to seek your agreement to note the written briefing and the consultation report. Is that noted then? Okay, thank you. Is any further information required, or members are happy enough with what you have got? Yep, you're happy enough. Okay, thank you, News. Moving on to item 8, domestic abuse and protection notice and orders. And again, this is a written paper from the department on pages 719 to 728. And again, just to advise you that the written briefing from the department on the progress to introduce regulations to make the provision for domestic abuse protection notices and domestic abuse protection orders, and to advise you that the introduction of the regulations for this is a requirement under Section 27 of the Domestic Abuse and Civil Proceedings Act Northern Ireland 2021, and was added to the bill at the request of the predecessor Justice Committee. The department has not met the deadline for these regulations having been laid. So again, it's just to seek your agreement to note the written briefing, and if there are any further clarifications. Any issues, any members? Doug, yeah?
No, I'm content.
Okay. Justin?
Thanks, Chair. Yes, just further to my previous issue that I raised in terms of victims of abuse not being able to access non-molestation orders. Could we write to the department seeking clarification on that front? Seeking how it's going to be addressed?
Yep. Are members content with that? Yes. Okay. Sorry, Maurice, did you indicate, or?
No, just to agree. That's all.
Okay, so we're going to agree to that question coming in from Justin, and then just again to put it on the public end of the meeting. Obviously, Connie earlier raised just a right to the PSNI in terms of seeking additional information on the assessment of the figures and costs, and again the committee agreed to do that. So members are content. Okay, thank you then. Moving on to agenda item 9, the forward work programme. It's in your PECs, pages 730 to 740. And you're asked to note this document. Members content enough? Okay, thank you. News. Agenda item 10, correspondence. Again in pages 741 to 1447 of your meeting pack. And to draw your attention to a number of items, and again the opportunity to comment on those or any other particular items that aren't raised. So pertaining to item 10.2, to refer members to the correspondence from the Minister of Justice at pages 750 to 51, which is an invitation for myself and the Chair to attend the launch of the Executive's programme on paramilitarism and organised crime, the first study of the prevalence of adverse childhood experiences, and that will be taking place in Queen's University on Thursday the 6th of February at 9:30 a.m. So again, this is also to seek agreement from members to note this item and to ask them whether they are content for myself and Joanne to attend that launch. Are people content on that? Gemma, are you wanting on this one, or is it on another?
No, it's on one coming up, Chair, so you can.
Aye, let
go
me
on
run through these and then I'll come back to you. Is that okay? Thank you.
Perfect, yeah.
Unless it comes up, I'm reading it out. So on item number 10.7, just to refer you to the correspondence, again from the department, on pages 775 to 779 regarding the 2024-25 October monitoring round outcome, which was emailed to members on the 21st of November. And again, just to seek your agreement to note this item and to consider forwarding to the Finance Committee. Are members happy enough that we do that? We note and forward?
Yes.
Okay, thank you. Item number 10.10, to refer members to the correspondence again from the Justice Department on page 9112, which contains a request for additional time to respond to our queries as a committee in terms of consideration of the open letter from the mental health champion. Are members content that we give a bit more time for a response? Agreed, yep, I'll take your silence as agreed. Item 10.14, refer members to the pack pages 934 to 979. And again, that was a forwarded return to the Department of Finance detailing the budget for 2025-26 equality impacts. So again, it's just to seek your agreement of this item and to consider forwarding it to the Finance Committee. So just seek firstly, do you note that correspondence?
Yes.
And content that we forward to the Finance Committee? Okay, thanks very much. Item 10.17, again to refer you to pages 984 of the pack, and it's from Jackie Durkin, the Chief Inspector of the Criminal Justice Inspectorate. Again, just to seek agreement from members to note this item and to consider writing to congratulate the Inspector on her reappointment. So can we agree to note?
Yep.
And agree to write the letter to Jackie? Okay, thank you.
Yep.
Item 10.20, again to refer you to 117 to 1171 of the meeting pack, and it's the establishment of the Northern Ireland Banking and Financial Services Landscape Inquiry. So again, just to seek your agreement to note this item. Obviously this is an inquiry through the Finance Committee, and to consider whether you have any views or information that you would like to contribute. So just if there's any views now that anybody wants to give, but I'm sure the Finance Committee has declared that I'm a member, will be happy to take any views from members anyway. Okay, so that's noted, members. Item 10.26 then refers to the Criminal Justice Inspection Report, Transforming the Criminal Justice System in Northern Ireland, a strategic overview. So again, just to seek agreement to note this report and to request, to consider the request for an oral briefing on the topic. So again, firstly, just to note the report. Are members content?
Content, yeah.
And do you have a view one way or the other for a oral briefing on this? I suppose transforming the justice system as a key issue, or do people want an oral briefing? Are members content?
Yes.
Yep, okay, yep, thank you. Item 10.28 then, just to refer you to correspondence from the Director General of the Northern Ireland Prison Service on pages 1389. And obviously the recent inspection by the Criminal Justice Inspectorate into Hydebank, Wood and the Women's Prison. So again, it's just to seek your agreement to note this item and to consider to offer a visit to the establishment and to hold a committee meeting there at a future date. Are members content? Yeah, on both, to note and then to do a future meeting out there. Morris, you looking in on this or? No, you're okay. Item 10.31, so just to refer you to a response from the NIO regarding biometrics retention within the Justice Bill and the Independent Commission for Reconciliation and Information Recovery. So just to seek that you note this and obviously to consider it when scrutinising biometric provisions. So are members content to note, and then we can pick up the correspondence again as we're going through our scrutiny?
Content.
Okay, no bother. Item 10.35, again, this is from the Human Rights Commission, and it's just a reminder to attend their annual Human Rights Statement, which has taken place next week, obviously as part of Human Rights Day and Week. So again, just to ask members to note this item and advise that the invitation and the link to register for the event, it's taking place here in Parliament Buildings. So are members content to note? Yep, thank you. Again, item point 1036. So just correspondence from Hourglass and a request to meet the chair of the committee to discuss recommendations for data collection for males over 65 with experiences or intimate partner violence. So just to seek agreement, obviously I'll consult with the chair in her absence, but if she agrees, members are happy enough that the chair does that. Okay, thank you. Item 10.37, again, this is around the Safeguarding Board to attend the conference on systems to support our people, embedding trauma-informed practice. So again, it's just to seek your agreement that the conference is there, so are members happy to note that? And again, there's a link there if people want to register for that conference as well. Thank you, that's noted. And then Gemma, do you want to come in on correspondence?
Yeah, Chair, it was just around that meeting with Gareth from Hourglass. I met with him on Monday and I would just encourage the Chair and yourself to meet with him or to present to the committee, whatever is easiest, but he has some interest in statistics.
No bother. I'll pick that up with Joanne offline, sure, and then we'll give the committee a wee update next week, sure.
Great, thank you.
Thanks very much. Okay, that's it then. Any other item, any other member wishes to raise under correspondence? No, people are happy enough then. We're just moving on to... Oh, sorry, can we just get you to note all the other items of correspondence? Members happy enough to note? Okay, thank you. So just item 11, chairperson's business. So again, it's just with regards to seeking agreement from members to write to the Department of Justice to request an update on the implementation of the Housing First model, with particular reference to the collaboration between the Department of Justice, Health and also the Department of Communities. So just again to seek agreement from members that we write to the Department of Justice asking for information on the difficulties of people being released from prison because they are unable to secure an appropriate bail address, with particular reference to statistics on this issue and any other ongoing collaborative work with the Housing Executive and also housing associations. And also to seek members' agreement to write to the Minister for Communities, the Lady Chief Justice, the Chair of the Housing Executive and the Director General for the Prison Service, and also the Department of Health and Probation Board, just in terms of the work of Inverary House and to encourage them to visit. Are members content that we engage with each of those pertaining to each of the issues there? Members are content? Yep, thank you very much. Item 12, you'll be glad to know any other business. Are there any other items that members would like to raise? No? Okay, just to advise you then, the date and time of the next meeting is next Thursday, and it's at 2 o'clock here in room 30. Oh, Justin, sorry, go on ahead.
Just very quickly, I would like to commend the Clark and the Clark's team in terms of their diligence, in terms of their professionalism, in terms of their detail and attention to detail, and the presentation that they gave us earlier. It was extraordinary, and thank them all. It's a great piece of work for Caroline, Johnny and Aaron. Thanks a million.
Thanks, Justin. Agree with that. And you can bring them mince pies in for the last meeting next week. Along with your Christmas jumper. You have to wear Christmas jumpers next week. No, again, that's it. We'll just bring the meeting to a close if members are agreed. Thank you.
Committee Room 30. Sound. 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 Committee Room 30, 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 sound.